welcome to the latest of our HR Improve sessions, this one on attendance management. I'm joined by my colleagues, Grace Watson, who's a senior associate in our Edinburgh office, and by our wonderful professional support lawyer and legal director, Antonia Blackwell. For those of you who don't know me, I'm Simon Fennell. I'm a partner in the team. This morning we are very, very keen for you to ask questions as we go along, and we will do everything we can to try and answer as many of those as possible. As you'll have seen from the welcome slides, if you could direct your questions into the Q&A box rather than the chat, that would be most appreciated, and Antonia will monitor those as we go along, and hopefully we'll answer them as they come along. So if you pose a question in there as we go along with each particular section, we'll try and answer those at the relevant time rather than necessarily waiting right till the end to do it. The session is supposed to be an hour and 15 minutes, and we have timed it for the last sort of 10 or 15 minutes to be questions. But of course, if we get questions during the course of the session, which we hope we will, then we may well go into that section just with the last bits and pieces of the main presentation. So what we're going to cover today is some tricky areas with regards to absence management, why it's important, types of absence duties to make reasonable adjustments, and then we're going to look at some the differences between short and long-term absences. Grace is going to look at that for us. We're going to look at some tricky areas, and then moving on to looking at dismissal and alternatives to dismissal as a consequence of absence and the problems that it has caused you. So we move straight into the question of absence management and why it's important. Before I go too much further, I just wanted to address one key point, which sometimes gets lost and is really, really important to bear in mind. Absence management, particularly at the coalface, if you like, for the management, can become a little bit of a battle sometimes, it seems, between the management and the absent employee. But what's really, really important to bear in mind is that in the vast majority of circumstances, the absence is genuine, the illness is genuine, and isn't anybody's fault. The employee didn't want to be unwell, and they probably would prefer to be at work. Your business will have invested in them through training and development, and even perhaps recruitment costs right back at the beginning. And usually the best outcome of any absence management process is for a swift return to work. And an efficient absence management process can help that. But what we must bear in mind is that the absence management process itself will not make the employee's health any better. And the regular visits to occupational health aren't by themselves going to make the employee any better. And therefore those visits are best served at times when we think there is a likely return to work, or where we have a complete dearth of information in relation to their particular illness. So what we're going to be looking at today is the need to balance the management time against the cost of getting things wrong, because of course getting things wrong can lead to unfair dismissal claims, disability discrimination claims, and of course those horrible legal costs that come around with them. And so the management time needs to take into account how we could support them, how we might rearrange the role, and moving forward into the fact that those managers might end up being a witness in a tribunal. So all of those things we're going to try and look at during the course of today. And we're going to start by considering the different types of absence. So we've got basically things will fall into a number of categories. If we've got genuine sickness absence and willful absence, if you like. So willful absence, those circumstances where an individual isn't necessarily ill, but is still ringing in sick. People call that malingering, or indeed you might have unauthorized absence, where they simply fail to turn up without proper or reasonable explanation. Malingering and unauthorised absence are a significant problem. And they're often, if you've got evidence of it, will be treated as a conduct issue. And therefore, we're going to separate those from today's session. In today's session, we're simply going to focus on looking at managing genuine sickness absence. We accept that the individual is genuinely ill, and probably that's the most common scenario that you as an employer are likely to face on any given day. But the first thing that we want to talk about is is reasonable adjustments, because reasonable adjustments is something that will come up and sort of lurks behind the scenes in relation to this whole subject, whether that's short-term absences or long-term absences. As I say, a recurring theme, more and more people are able to satisfy the definition of a disabled person under the Equality Act, which you've got on the screen in front of you there. And quite rightly, that category is expanding all the time. You'll have seen lots and lots of articles recently, both by us and by other voices in the legal world, and indeed recently case law, with regards to extending the area of disability, and the fact that more and more conditions such as menopause are likely to have an impact and be caught within the protection. It's really, really important to understand that you need to have knowledge, of course, of a disability before the duty kicks in. But that knowledge doesn't have to be actual knowledge, i.e. the individual doesn't have to have told you that they are suffering from any particular condition. The law will expect the reasonable employer to make an adjustment if it could reasonably have been expected to know that that individual has a disability. And that will include witnessing changes in an individual. So if somebody's performance changes, all these things that and there's no obvious explanation for it, the reasonable employer might be expected to ask questions as to what is what may have been causing that. And the same will be the situation if somebody is suddenly absent when previously they have been well. Just as a recap, the obligation arises as a consequence of a provision, criterion, or practice. Because of that, a disabled person suffers a substantial disadvantage than a non-disabled comparator. The duty is to take steps essentially to reduce or remove that disadvantage, or if you want to put it in layman's terms, re-level the playing field. So the purpose of that adjustment has been the subject of some case law, and in the Salford Primary Care Trust case, the Employment Appeal Tribunal commented that it was the purpose of the adjustment was primarily concerned with enabling the disabled person to remain in or return to work with the employer to enable the disabled people to play a full part in the world of work. So it's all about when they're ready to come back. The consideration of a reasonable adjustment is unnecessary in circumstances where you have somebody who is still completely unwell and has no prospects of an immediate return to work. It's a duty that's imposed to enable somebody to come back to work, or indeed to remain in the workplace. Taking that the next stage forward, we need to consider, when we're looking at adjustments, what will be considered. Now, there is actually an awful lot of guidance out there, and the Equality and Human Rights Commission have issued, a long time ago, issued a statutory code of practice, which if you simply Google code of practice, Equality and Human Rights Commission, you'll find it. And that is a statutory code of practice that an employment tribunal must take into consideration when considering disability cases, and it is full of worked examples, if you like, of circumstances where a particular absence, particular health obligation might trigger the need to make adjustments, and give some examples of what may or may not be reasonable in any given circumstances. But you'll see there on the screen that we need to consider to what extent the adjustment would have an impact to change that disadvantage. To what extent will it actually work? To the extent that that adjustment is practicable in the circumstances. Yes, it might work, but the reality is that to provide that particular piece of equipment or to do whatever it might be that totally removes that advantage is not practical. The employer who works on the top floor of a very old building that doesn't have a lift access and cannot have lifts provided, it would be impractical to try and impose an obligation to install a lift. So we need to consider also the financial and other costs of making the adjustment, the extent to which they would disrupt the employer's activities. Cost can't be the only consequence. We need to be seen to ensure that cost isn't the only barrier, and it's unlikely to be the only barrier in reality. The resources available to that particular employer. So a much bigger employer will have a higher duty to make different adjustments than your smaller organisation. External, we should be considering whether there are external financial or other assistance available. There are many organisations, both charitable and centrally funded, that can provide additional assistance to employers in respect of the provision of both assistance through people and guidance, and also through the provision of grants to enable you to either fund mobility, such as access perhaps to and from the workplace, or indeed the provision of aids and equipment within the workplace. So with all of those things in mind, the courts have considered, of course, many times what will be and will not be a reasonable adjustment. And I warn you now that some of you will look at the things on the screen here and think that how could that possibly be considered to be reasonable? And that really wouldn't work for us. And crikey, if that was everything that was, if we were expected to do all of that, we'd go bust. Now, the fact of the matter is that for every single example that we can give you, they have a unique set of facts, and every single circumstance is going to be different. And if your circumstances are different to the decided cases, then the decided case can only be guidance. And what may be reasonable in one case may not be reasonable in another. But just looking at some of the things that are on the screen there, you'll probably all have been on a flight where the announcement comes over straight away, because whenever the first passengers get on, that there is a passenger known to the crew who has a nut allergy, and consequently no nuts will be served on that flight, and they ask everybody to not consume nuts during that flight. And that's a reasonable adjustment. And so it shouldn't really come as much of a surprise that an employment tribunal in a particular case says that to introduce a no cosmetics policy to prevent an individual who has a life-threatening sensitivity to aerosols and perfume was a reasonable adjustment. But you might also say, however, that it's not surprising to allow somebody to work from home if they've got a fear of crowds. However, that's not always going to be possible, because if you're in a job that requires you to have day-to-day interaction with people on a physical one-to-one face-to-face basis, clearly that's not going to be reasonable and practical in that particular circumstance. We could say the same for all of the other adjustments there on the screen. And this is the point. We need to be taking each set of circumstances and each set of facts by itself and looking to see, using case law, using the Equality and Human Rights Commission guidance as just that, guidance, to help us make a decision as to what might be reasonable and what isn't. You'll be pleased to know that there are judgments, and just as many probably, where tribunals held that things were not reasonable in the circumstances, and we'll take a look at those now. You'll see that many of these come in relation to pay, and I just want to address that, because the idea, you remember, of the reasonable adjustment is to level the playing field. And level the playing field and return somebody to work, or entitle somebody to remain at work. And the purpose of sick pay serves neither of those purposes. The idea of sick pay is support for an individual while they are off. The provision of company sick pay or statutory sick pay has nothing to do with getting an individual back into the workplace, and has got nothing to do with whether or not that an individual who is in work can stay in work. And therefore the tribunals have said, well, it's not a reasonable adjustment because it doesn't serve those purposes of levelling the playing field. So you can see that where an employer was asked to adjust sick pay policy to enable a disabled employee to continue to receive sick pay for longer than their non-disabled colleague, that was dismissed. It wasn't deemed to be a reasonable adjustment. So there is some help there for employers in those circumstances, and it always comes back to that idea of what is the purpose of this adjustment? What is it going to do? Is it going to solve that particular problem? Is it going to help ameliorate that disadvantage? And if the answer to all of that is no, then it's not going to be considered to be a reasonable adjustment that a court would impose upon you as a reasonable employer. And it's a pretty stern and pretty objective test. Now, I remember many years ago, live examples are always helpful, aren't they? So I remember many years ago, I was in an employment tribunal and we were defending a case where an employee who had lots of quite long-term absences, but in chunks. So they might be away for a month or so at a time, and the numbers tend to work out that they were going to be absent for about a third of a year every year, because that was the pattern that had been displayed. And they said, well, I will be better off if I can work at home. Now, you might want to consider that as an option. And we said, well, there are things that need to be done in the office, and so you'd need to come in sometimes, but we could probably agree for you not to be at work or not in the workplace for the majority of the time. And they said, no, I'm Polish and the rest of my family lives in Poland, and therefore the obligation should be for me to work from home in Poland. And the tribunal disagreed completely and said, no, that's not a reasonable adjustment in the circumstances. The business case is for you to be needed to be at least available and close by to be able to come in as is needed. And therefore, the additional extra burden there of being out of the country, leaving aside any taxable issues that might give rise to, was unacceptable. But what was really, really helpful on that particular case was that the judge even went so far as to point out that with the level of absence that that individual was displaying and the pattern that they were displaying, that actually the employer might well consider whether or not that level of absence was sustainable at all. And if they decided that the business case was that that level of absence was not sustainable, then that would probably also lead to a fair dismissal. It's safe to say that sometimes you do actually have a really good day in court. So that's enough from me for the moment. I will pass on to Grace to talk about short and long term.
I was just going to say, actually, Simon, that unsurprisingly, reasonable adjustments has triggered some questions coming in. So I wondered if we might just take a couple, I think,
Sure.
Just a couple of quick ones before we move on to Grace's section. So one of them is a question, would a change of line manager be considered a reasonable adjustment? The employee is saying it's their current line manager that causes them stress, which is leading to migraines. And I guess that comes back to your point, doesn't it? Well, is it reasonable? Is it actually something that we can do? Is there another line manager that could be put in place? And will that alleviate that disadvantage? And is it actually about the line manager, or is it about workloads or capability issues?
Totally agree. I mean, if you take I don't know, an example where you're in a manufacturing business, for example, where there are a number of different manufacturing lines, and therefore the role that individual is doing is repeated in a number of different places across the business. It may well be very possible to trial that perhaps and move, just swap somebody out, maybe even as holiday cover or something while somebody else is away, so you're not even disrupting the rest of the workforce, and just move them in there and see what difference it makes. Because one of the most powerful pieces of evidence that you can possibly give to an employment tribunal in any circumstance, whether it be reasonable adjustments or flexible working or anything else, is to give it a try. And if you try something and it works, brilliant, you've solved the problem, which, let's face it, that's what we want to solve, the problem. If it doesn't work, you've got fantastic evidence to demonstrate that that is not reasonable. And if that is the whole thing that individual is hanging their hat on with regards to a reasonable adjustment, and you can prove that it doesn't work, you're on pretty solid ground.
Yeah. And the other one was around an employee who'd chosen to move, and then when they were now struggling with their commute into work. And I guess again that comes back to the point similarly the case you were just discussing, which is, well, can you look at whether they can work from home, but presumably there is some requirement to be in the office, and if they are struggling with that, then that might mean that there isn't a reasonable adjustment that you can do that alleviates that disadvantage. But I think the tribunal would bear in mind it's been their choice to move, but I don't think that gets you off the hook as an employer in terms of looking at reasonable adjustments.
No, I'd agree. I think they will be sympathetic to the employer in those circumstances to a degree. And I think there are lots of employers who find themselves in that exact position now, particularly post-pandemic, where
Yeah.
there was this whole, well, look, I've worked from home for a year and it's not had any problem. Therefore, they can't really argue that if I move away, it's going to cause too many other problems. But of course, the world changes and everything changes. And whilst the world was prepared to accept remote working for a considerable period of time, there are, the world of work has changed and will never go back to where it was. But there are other demands and consequences and reasons why people might want to be have people in the workplace. So I don't think it was your choice is the answer. And it just comes back to all of those other things. Ask the questions as to, is there anything else that can be done? Can we accommodate it some other way? Even, and you've got to think outside the box sometimes. If they've moved away a particular distance and they're struggling, can you say, right, well, we need you to be in 2 days, but we can make sure that those 2 days are together, and so perhaps you can stay locally in a hotel.
Yeah.
And do things that way. So you don't have to commute every day. You can be in, and we can even say, well, we're prepared even to allow you to work longer hours those days because you're not having to do the commute. You're the local, you're going to be staying nearby. So, perhaps you can do more hours those days and spread out the rest of the week. All of these things you should be just giving some consideration to. And I think that's part of the problem sometimes is that people aren't willing to be flexible enough to give consideration to all of the options, or they don't expand their mind sufficiently to be creative enough, because just a little bit of creativity sometimes goes a long way to either demonstrate to an employee that you're trying, even if they don't end up being practical, or you do find a solution that works for everyone.
Thank you.
Grace.
Thank you. So could we move on to the next slide? Thank you. So I'll first talk through the two different categories of sickness absence, short-term and long-term absence, and then I'll start talking about some tips for how best to manage them, and what can be done when absence starts to become a problem. So if we can move on to the next slide. So sickness absence tends to be divided into two broad categories, which is short-term absence, and by that we mean minor one-off absences, which are for short periods, i.e. lasting a day or days rather than weeks. And examples of those types of absences might be, absences for things like colds, migraines, or minor injuries. The second type of absence is long-term absence, and by that we mean an absence that's lasted or is expected to last for a significant period of time, and that will normally be due to a more serious health condition. A common example that we quite often come across in our cases is employees who are unable to work for lengthy periods because of musculoskeletal problems like debilitating back pain. Seems to be quite a common long-term absence issue. And other examples could include employees who have been off for lengthy periods for things like depression and cancer. So we could pop on to the next slide. So both long-term and short-term absence can become problematic for a business, and therefore it's really important that both are managed correctly. So I'll be looking at some steps that employers can take to manage short-term absence, to both mitigate the likelihood of absences becoming persistent in the first place, and to weed out potential instances of malingering. I'll then look at what steps can be taken to manage and address both persistent short-term absence and longer-term absences. So in terms of what measures employers can put in place to manage short-term absence and discourage malingering, the first thing to have a think about is absence reporting requirements. You should make sure that these are set out clearly somewhere that's accessible to employees. Most companies will have policies in place setting out reporting requirements for notifying managers of sickness absence. More often than not, there will be something in a policy saying that the employee must inform their manager before their shift if they're not going to be able to attend for work. So one practical tip to consider is introducing a requirement for an employee to actually phone in and speak to someone to report their absence. Psychologically, there's slightly more accountability involved in that, in having a direct conversation with someone rather than simply, sending an email or a text. It's a small tweak to an absence procedure that might actually assist in reducing instances of malingering. So where an employee does phone in sick, it's a good practice to establish with them the reason for their absence, how long they anticipate being absent for, and if the absence is expected to be more than one day, agree a means of keeping in touch with them, a way in which they'll update you about how they're feeling as it progresses. In terms of proof of fitness, for short-term absences, there's unlikely to be a fit note from a GP, and that's because there's no requirement for a fit note where the absence is less than 7 calendar days. So in most cases of short-term absence, the employee will be able to essentially self-certify themselves as genuinely ill. And so again, a practical tip would be to have requirements in your company's policy about how an absence should be self-certified. I know some employers require employees to actually fill out and submit a self-certification form for short-term absences. And again, that just adds another degree of accountability on the staff member. And so a final practical tip, and this is an important one for managing short-term absence, is to hold a return to work meeting with an employee whenever they return from any period of absence. As I said, that's very important, and managers can use that return to work meeting to properly understand the reason for the absence and whether any future absences are likely to occur. So a return to work meeting really provides an opportunity to explore whether there's any underlying reason behind that absence, and will very often inform the next steps that need to be taken. So it might be the case that a return to work meeting takes place and both parties are very clear that the absence was a genuine one-off and is, unlikely to reoccur, so nothing further is needed. But it may become apparent in a return to work meeting that, in fact, the employee does have an underlying condition that they need some support with. Alternatively, it might come to light that there are underlying problems in the workplace. For example, maybe the employee was off with stress because of, a dispute among colleagues. So it can bring to light issues that might otherwise have gone unnoticed or unaddressed. So these practical steps all place a degree of accountability on staff, and if they're carried out consistently for every short-term absence, staff may think twice about phoning in sick when they're not actually sick. But beyond reducing malingering, carrying out these steps ensures that as an employer you have a paper trail of all absences and the reason for those absences. And that will assist in allowing you to identify and address patterns of absence much more easily. So we can move on to the next slide. So occasional absences can generally be absorbed by the business. There's some level of sickness absence that is part and parcel of running a business with employees. But where an employee starts persistently calling in sick, that can cause major disruption. The point at which persistent absence becomes a problem will vary from business to business. And it's advisable to have a written procedure in place setting out the steps that will be taken where short-term absence levels are deemed to be unacceptable. And ultimately, where levels of short-term absence reach a point where they become unsustainable for a business, you might be in the territory of dismissal. But before dismissing, tribunals will look at whether the employee has given appropriate warnings about the potential consequences of failing to improve absence levels. So key to managing short-term absence is putting in place a system whereby warnings might be issued in appropriate circumstances. So where an employee has had a series of short-term absences, it's good practice to invite them to attend a formal meeting to discuss their absence levels. There are no magic numbers in law in terms of what levels of absence would be regarded as unacceptable. It'll depend on the nature and the size of the business. I know some large organisations use systems such as trigger points, so they'll have a policy actually stating that X number of days within a certain period will automatically trigger a formal meeting that might result in an absence warning, whereas smaller organisations are more likely to have a bit more discretion about when to call an absence meeting and at what stage they regard the absence levels as being unacceptable. So if you reach a stage of a formal meeting, during that meeting, as an employer, you'd be expected to explain to the employee the impact that absences are having on the business. For example, explain the difficulties that are created when cover needs to be found at short notice, or the overtime costs that are having to be incurred in having staff pick up additional shifts. And you would seek to explore with the individual whether there's an underlying cause for the absence. And if the individual is able to identify an underlying cause, that should be explored. So for example, it may be that at that stage a medical condition is disclosed that requires further investigation. That would be through occupational health. Or it may be that there's a wider workplace issue that needs to be investigated and resolved. But where there's not an obvious underlying cause for the absences, it might be appropriate to issue the employee with a formal warning. And as part of that warning, you would set a timescale within which you would expect to be seeing attendance levels improving. I know some companies refer to that as a monitoring period. And employers need to have issued an employee with at least one formal warning before dismissal for short-term absence could be contemplated. However, in practice, most employers will have a system for issuing a first warning and then usually a final warning before reaching the stage of contemplating dismissal. So we could move on to the next slide. So long-term absences are managed in a slightly different way to short-term absence. So where the reason for a lengthy absence is due to a genuine long-term health condition with potentially an unclear prognosis, it's unlikely to be appropriate to issue a series of absence warnings in the same way as you might do where it's persistent short-term absence. If a health condition is serious enough for the employee to have been off for a lengthy period of time, there's a high chance that that condition might amount to disability within the meaning of the equality legislation, and therefore issuing an absence warning in those circumstances may well be unfavourable treatment because of something arising from a disability, which would be unlawful. And alternatively, an employee might say that it would be a reasonable adjustment not to issue them with a series of absence warnings. And on a practical level, issuing a series of warnings is unlikely to have any effect if the employee is genuinely very ill and not going to get better. So usually during long-term absences, a series of meetings will take place with the employee. Different organisations use different names for these meetings. I know some companies call them welfare meetings, some refer to them as check-ins, and some companies will just call them absence meetings. Key to managing a long-term absence is having these meetings and seeking to understand the ongoing medical position. So you should ask the employee during these meetings for their own views about how they're doing and when they might be better, what adjustments they feel would assist them to return to work. And in addition to doing that, you should seek advice on these questions from a medical professional. And that will usually be done by making a referral to occupational health and asking the doctor to provide advice on those questions. So normally you would be asking a doctor to advise on whether the employee is fit for work, how long it's likely that they will remain unfit, whether they'd be able to return with adjustments, And the types of adjustments occupational health might suggest would be things like reduced or flexible hours or an alternative role. Quite often, occupational health will make a series of recommendations as to adjustments that might be possible, and then it would be for the company to make the determination as to whether they were reasonable, as Simon had outlined earlier. So once you've obtained a medical report, the conclusions should be discussed with the employee. It may be that it becomes clear that the prognosis is good, and you're able to identify measures that would assist the employee to return to work, and therefore you could agree a timescale and a manner in which they'll return. Alternatively, it might be the view of both the employee and the medical professional that the employee is simply not fit to return at that point, or that it's unclear when they'll be able to return. And in that case, it would be sensible to agree a rough timescale for review of the position. In terms of how far into an absence these meetings should take place, again, there's no set timescales in law. It will usually depend on the individual circumstances. Some organisations have policies which state that a meeting must take place after a certain number of weeks of absence, whereas in other cases it might just be that maybe the submission of a second fit note prompts a meeting to take place to find out what's going on. Either way, it's important that you ensure you are having these meetings with absent employees and not just allowing the situation to drift. So just a quick point on the right to be accompanied, if we could move on to the next slide. So employees have a statutory right to be accompanied to meetings where dismissal is a possible outcome. Where there's no possibility that a sanction will be issued, strictly speaking, there's no right to be accompanied. However, in cases of involving potentially very ill employees, it might be good practice to allow them to be accompanied to sickness absence meetings anyway. And in some cases, you may want to consider allowing them to be accompanied by a friend or a family member, rather than the usual categories of, just a trade union representative or a colleague. A further consideration might be having a meeting with the employee at their home where they're very ill, or another convenient venue, rather than requiring them to come in to the company premises. So it's just being mindful that in cases of long-term absence, the employee might be dealing with very serious health issues that require a sensitive approach. If we could flick on to the next slide. So where an employee does return to work following a period of long-term absence, it's really important to ensure that the return is properly managed. We do see quite a lot of cases, not necessarily arising out of the absence, but arising out of what happened when the employee returned to work. The fact that an employee has returned to work shouldn't herald the end of all management of their ill health. So in many cases, an employee might return on a phased return. So, maybe starting off part-time hours, working back up to full-time. And it's important to be clear at the outset about what sort of phased return is envisaged. It would also be prudent to meet with the employee at the end of the phased return to check that they are actually fit to return to their full-time role. If any adjustments have been put in place to help the disabled employee come back, you should monitor these and ensure that they are in fact working. The duty to make adjustments is an ongoing positive duty, and therefore it's important to continually review that and check whether there are any further adjustments that could be made, and indeed whether the adjustments that have been made are working. So there may come a time where absence can no longer be sustained by the business, and at that point a business might start to consider whether they ought to dismiss. So I'll talk about that shortly, but before we go into that, I think Simon is going to talk to us about some tricky areas that sometimes crop up in absence management.
And actually, Grace, your section is throwing up quite a lot of questions. So I wonder if we just take a few of them, not necessarily all of them, because I think we might run out of time. So we take some of them. So one I thought was quite a pertinent one, which is what if the employee is just not giving any reasons for their absence, just says they're ill and is not really kind of cooperating. And the delegate has said obviously there'll be a meeting to try and discuss with them, explain the benefits of sharing that information. But if they are really refusing, so the question is, can they make it a criteria on receiving sick pay? Well, certainly not for statutory sick pay purposes, because that's a statutory right. Potentially for contractual sick pay, but it tends to be more a case of going, well, if we can't get more information, we have to make decisions based on what you're telling us and the information that we have got available, and sometimes that means we can't make the best decisions, but ultimately if you can't get information, you have to go on what you have got. I don't know whether Simon, Grace, you've got anything else to add to that.
Yeah, that does happen now and again, and I find that usually it's a case of writing out to the employee and saying, look, if you're not prepared to cooperate with these requests for a medical opinion, we will have to make decisions about your employment in the absence of medical advice. And in my experience, that's usually enough to prompt them into cooperating. But ultimately, that if the employee won't attend a consultation with a medical professional, as the employer, you do just have to proceed and make the decision as best you can without medical advice. And I think in circumstances where you've encouraged an employee to engage with the process and they haven't, a tribunal will have a degree of sympathy for the employer.
Yeah.
Yeah, I think it's just quick add to that is that if they're not telling you anything, the obligation on constructive knowledge is even more important. And just because they're not telling you something doesn't mean that you're absolved from what you can see and what you can, what's obvious. So, I think that's, I think that's a really important factor as well. It's what you can tell from the fact that they're not here, but equally what you can tell by looking at them, seeing them, what they're experiencing. And I think you have to make assessments on that as well. You can't just be blind to the fact that somebody is clearly, obviously ill in front of you.
Yeah. And we've had a few questions around occupational health. So one of them, would occupational health contact the employee's own GP to understand the issues? Potentially. A lot, I think, will depend on what the condition is and what's going on. But certainly, I've seen OH reports where they've gone to the GP. Obviously, if they'd have to then comply with access to medical records reports. So there's various statutory requirements around the employee being able to see a copy of the report first and that sort of thing. But yeah, that's an option for OH. I don't suppose it will be relevant in every situation, so it will just depend. Can occupational health referral be used just as a sense check on reasonable adjustments? Yeah, I think that's a really good idea. It doesn't have to just be to get a medical opinion. It could be to ask for advice. And actually, I think that's a really good way of kind of going, well, have we thought about all the potential reasonable adjustments here? And then there was just an interesting one around the long-term sickness considerations where there's an addiction problem. So addiction itself is not a disability under the Equality Act, but obviously a lot of addiction causes other health conditions, and those other health conditions could well be disabilities. And so I think there's still all the things that Grace, you've been talking about are still considerations. I think you need to explore what the issue is and what is the cause of that issue and whether that could be a disability. Okay.
Fantastic, thank you, and thank you everyone for engaging in so many questions. Apologies if we don't get to answer all of them. So just turning to some tricky areas and how we would deal with those. And we start off with the thorny issue that happens more often than you might think. An individual returns to work before their sickness absence certificate has expired. Sorry, could you just move on the next slide? There we go. So they're technically remains signed off, but they present to you as unfit to come back to work. Now it causes a real difficulty, and I think, and there are occasions where, unfortunately, the expectations or obligations on an employer sometimes conflict with the demands that we place on our GPs, because on the one hand, you as an employer are expected to believe and accept the content of a fit note. And certainly if you were to challenge an individual who tells you that they're sick when they've got a fit note, you've got to have some pretty good evidence as to why that's the case. But then when you're suddenly presented with an employee who says, I want to come back to work, notwithstanding the fact that my fit note is still in place, if you send them to the GP to get a medical certificate to certify them back to work, A, if they can get an appointment, then great, but B, anecdotally, GPs are not terribly pleased with that position, and they say, well, you should accept the fact that an employee is now telling you they're fit to return to work. So we have a little bit of a conflict there sometimes. But nevertheless, what can you do in the circumstances where it happens? Well, the first thing is that it potentially gives you an issue on a health and safety basis, because you've got an individual who, on the one hand, the medical evidence says they're not fit to return, but they're telling you that they are. And I think it's unfortunately one of those cases where you actually have to consider the nature of the reason why they've been absent to start with, and take a look at that and why it is that they now say that they are coming back to work sooner than they might otherwise be. I mean, if you think of somebody who's got who had a really bad physical injury, which meant they couldn't travel and therefore they couldn't come to work, but that's healed more quickly than they originally had anticipated, and that might be it might have been a break or something, or a really bad sprain that they're going to be off for 6 weeks, but actually they've made a much quicker than expected recovery, and they're able to return to work after 4 or 5 weeks. That's something where you may well be able to extend your discretion slightly easier and accept that we can measure that risk and assess that risk, and provided that it's clear that the individual wants to come back to work, that we can deal with that. But there might be other circumstances where the reasons behind an individual coming back to work are slightly more difficult for you to deal with. So you might have that situation where an individual has been off on relatively long-term sick, and you've had to contact them with that difficult news that sick pay is about to expire, and notify them that as of the end of this month they're not going to receive pay anymore. And that might be the trigger for somebody to come back to work, simply because they can't afford not to be receiving payment. And that presents you with a really, really difficult position, because if that's a particularly a mental health problem, for example, and the individual still isn't really able to be at work, and they shouldn't be at work, and it's simply because of pay that they are at work, the fact that they've got a medical certificate that says that they're unfit for work, I think, will in those circumstances be the overriding factor, and it will be up to you as the reasonable employer to take steps to go back and obtain medical advice with regards to whether or not that individual really should be at work or not, which does in itself give rise to a question about pay and what would you do in those circumstances, because of course an individual who presents themselves as available to work, and you say, I'm not going to let you work, may have an expectation with regards to being paid. And certainly if an individual is sent away from work in the absence, whilst you obtain medical evidence, you might often call that, you might see that referred to as medical suspension. And you would be expected to pay that individual in those circumstances, or until such time as you could see that they were actually unfit, or if there is an existing fit note, maintain their absence. But if they are deemed to have been fit for that window where you've sent them away again, you'd probably have to reinstate their pay. But I think in those circumstances, you would be entitled to say, until you can prove to me that you are fit to be at work, I am going to rely upon the medical certificate. But it's a really, really difficult situation, and as I say, one that comes up more often than you might otherwise anticipate. Now we've had a question about holidays, and so I'm just going to turn to holidays anyway on the next topic. And when people are able to receive holiday and what the situation is with regards to pay, we had a huge number of cases many years ago now. It's quite settled law in terms of holiday pay, or at least it was until we left the EU, with regards to holiday pay and what happens. So an employee or a worker will accrue and can take holiday during a period of sickness absence. A period of holiday will not break sickness absence. You will not be, you should not consider somebody to be fit simply because they take a period of absence. And it doesn't really matter what they do during that period of absence. You know, we often have people say, well, this individual's supposed to be signed off work with depression, and yet we've just seen on their Facebook page that they've been at Disney World. Well, depression is a very difficult and challenging thing, and just because somebody is able to go off and enjoy a holiday actually may be part and parcel of their recuperative process and shouldn't be taken against them. They are allowed to take holiday. As I say, they continue to accrue holiday during sickness absence. If they're unable to take sickness absence during the course of, if they're unable to take holiday during a course of an annual leave year as a consequence of their sickness absence, then they're entitled to carry that over into the next year, notwithstanding the fact that the working time regulations typically say that holiday shouldn't be carried over. But there will be a limitation to that, and the limitation is probably around 18 months or so, in terms of, after a period of 18 months, there was a European court decision that identified that holiday, the purpose of holiday, is to give people a rest away from work. And consequently, logic would say that if you've been absent from work and not working for a prolonged period of time, the reason for taking holiday has diminished. And therefore it wouldn't be right to continue to accrue holiday in circumstances where the need for holiday doesn't exist anymore. And in that situation, they said that a period of 15 months perhaps between commencing sickness absence and ceasing to accrue holiday leave was about right. In the UK, we think it's probably going to be, it's around 18 months. So from the moment they start absence until 18 months on, they can continue to accrue holiday and holiday leave. Right to rearrange pre-booked sickness absence. So if I've got some leave booked, I'm entitled to cancel that. If I become ill ahead of that holiday, I can cancel that and have it added back to my allocation and reallocate it for myself later on, or even carry it over into the next year. And similarly, I might be on holiday and be taken ill, and I then have the right to cancel remaining holiday and have that carried over or allocated at another time. However, it is perfectly proper and right that if that is going to happen, that employee evidences to you that they are properly absent and sick in the same way that you would expect them to report absence if they were normally at work, i.e. they should be contacting you on the first day of absence to tell you what the situation is, and the fact that they want to cancel their holiday and have it allocated as sickness absence instead. It's not appropriate in majority of circumstances. There will always be the exception, but in the majority of circumstances, for an individual to return from their 2-week summer holiday or whenever holiday and say, I was actually ill during that and I'd like to cancel that and reallocate it somewhere else. It's a in the moment decision. They need to be reporting to you because, of course, it is absence. And if they don't report to you and follow your procedures, you may well be able to say, well, you didn't follow that procedure. We're not going to do that for you. So those are some of the issues with regards to holiday. When somebody gets to the point where they might be leaving and they're during their holiday, and we're looking at notice pay, this is a very quirky piece of law, and it's one that all of us look at and say it's a really odd and unusual, strange one. If your so this is in circumstances where an individual is being dismissed or resigns in circumstances where they have exceeded their sick pay and are no longer being paid in receipt of salary. If their contractual entitlement to notice pay is exactly the same as the statutory minimum, and the statutory minimum, of course, is 1 week's notice for every completed year of employment up to a maximum of 12. So if that's their entitlement, then they are entitled to receive full pay for notice given to them by the employer, even in circumstances where they're not otherwise receiving salary. Now, the odd one and the exception is that if the contractual notice period, if the contractual notice period is at least 1 week more than the statutory minimum entitlement, then there is no pay entitled in circumstances where they have exhausted their company and statutory sick pay. Slightly odd. I think the idea being that the compensation, the additional compensation provided for the longer notice period offsets the pay. Clearly doesn't, but that's the way that things are. So if your contractual entitlement is, say, 12 weeks, or let's say it's 3 months, it says it's 3 months, and 3 months is 13 weeks, and you've got somebody who's contractually entitled to 10 weeks, then in these circumstances, they wouldn't be entitled to any payment at all. And you'd continue to have them off sick and not pay them anything. Really odd one, but nevertheless, that's the law that we deal with. And then finally on this area, just want to look at pregnancy-related illness. So there's a protected period for anybody who is pregnant. The protected period technically starts from conception all the way through to the end of the maternity leave period. In real terms, of course, that's going to be a question of knowledge. When were you aware that the individual is pregnant? But that is a protected period, and in that protected period, you must treat pregnancy-related absence in a particular way. For example, if you use your Bradford Factor score or 3 periods of absence, and we issue a warning, or those kinds of things, any pregnancy-related absence must be discounted from that calculation. And must be effectively ignored for the purposes of any sickness absence management process. And that's the same all the way through that protected period. And of course, the protected period ends when the maternity period ends, and therefore you can and should treat any absence that arises after the maternity period has concluded, including any absences that still arise from pregnancy-related illness, such as postnatal depression. You will treat those in exactly the same way as you would any other absence, if that is at the end, or so after the end of the maternity leave period. Very conscious of time, so Grace, unless we're going to take any questions at this point, Antonia, we'll move on to dismissal process.
Thanks, Simon. So it is worth recapping briefly what the law says about dismissal. So the law says that dismissal of any employee with over 2 years service will be unfair unless that dismissal can be shown to have been for a potentially fair reason and it was reasonable in all the circumstances. And part of the assessment of reasonableness includes consideration of whether or not a fair procedure was followed. So we could flick onto the next slide. So there are 5 potentially fair reasons for dismissal, and dismissals for absence will generally fall under the capability heading. Oh, sorry, could we go on to the next slide? So these are the 5 potentially fair reasons for dismissal. But as I say, dismissals for absence will generally fall under capability, i.e. the employee is not capable to continue carrying out the work for which they're employed. However, in some cases, short-term absences could be treated as dismissals for some other substantial reason where it's potentially not down to their capability to carry out the job. It's just that the business cannot absorb their level of absenteeism. And again, conduct dismissals might come into it where the absence is willful, so malingering or unauthorised absence. So if we could flick on to the next slide. In all cases where dismissal is contemplated, procedural fairness requires that the employee is warned about the dismissal. And therefore, anytime you're inviting an employee to a meeting where the potential outcome could be their dismissal, it's really important that it's made very clear in the letter inviting them to that meeting that dismissal is a possible outcome. And it would also be good practice to recap that at the start of the meeting. I have had cases before where the employee has claimed, oh, I had no idea dismissal was a potential outcome of that meeting, and had I known that, I would have approached it in a different way. So in terms of dismissal on grounds of persistent short-term absences, in the formal meeting, you should look once again at whether there's any underlying cause for these repeated absences. And as I said before, if at any point the employee comes out with further information about the underlying cause, further investigation would be required before a decision to dismiss could reasonably be made. But assuming that there's no underlying reason for the absences which would give rise to any cause for concern, you should recap the previous warnings the employee has received and explain to them again the impact that their absence is having on the business. You would recap the targets for improvement that had been set and explain why these hadn't been met. And finally, you would need to give the employee the opportunity to state their case and provide any mitigation as to why they shouldn't be dismissed. So for example, it might be that they have 10 years service. They've got 8 years where their attendance was absolutely exemplary. And in the last year or two, they've just had a bad run of luck. And in those circumstances, dismissal may be a harsh outcome. But having been through all those steps, if the employer considers that absence levels are just unsustainable for the business and doesn't consider that the employee has put forward sufficient reasons as to why dismissal wouldn't be appropriate, dismissal is likely to be a fair outcome in those circumstances. And procedural fairness, of course, requires the employees are given the right to appeal any decisions. So it's really important that to include a right of appeal in any outcome letter. So if you could flick on to the next slide. So in cases of long-term absence, employers might reach a point where they conclude that the employee is not capable of doing the job that they're employed for, and therefore dismissal ought to be contemplated. Now, tribunals will generally expect there to have been at least 2 absence meetings with the employee, although in practice, in most cases involving long-term absence, there will have been many more meetings than that by the time you get to dismissal. And for a dismissal relating to long-term absence to be fair, the employer will be expected to have been taking reasonable steps to have established the medical position. So that will involve making a referral to occupational health, as we've discussed, or in some cases it might involve obtaining a report from the employee's GP. In cases where medical advice has already been obtained, you should consider whether that advice is still up to date, and if necessary, obtain a further report. So you must have fully consulted with the employee before making any decision to dismiss. Once up-to-date medical advice has been obtained, you would be expected to invite the employee to a formal capability hearing to discuss whether or not their employment can continue. And during that hearing, you would consult with the employee about the medical evidence, obtain their views on the likelihood of a return to work, and it's crucial that you consider alternatives to dismissal and invite the employee's views about possible alternatives. So alternatives would include things like redeployment into another role, if that was a possibility in the individual circumstances of the case. And finally, one point to mention is that you should always consider whether there's any possibility of the employee receiving income protection. I know a lot of companies have permanent health insurance schemes in place that employees who are very ill may be able to benefit from. So that should be, if that's a possibility, it should be looked at before the point of dismissal. And indeed, where there is the possibility of the employee receiving benefits under a permanent health insurance scheme, the employer might be duty bound to keep the individual employed while they're receiving those benefits, because most schemes will usually require the employer to keep the employee on the books. But having been through that process, if no alternative can be identified, then the decision maker will need to consider whether they can reasonably be expected to keep the individual's job open any longer. And that's a fact sensitive question. It'll depend on the nature of the illness, the nature of the employee's job, and things like the size of the organisation, the cost of keeping the employee employed, and the need to obtain, maybe someone to fill that role, will all be relevant factors in coming to a conclusion. So I'm conscious it's been a bit of a whistle-stop tour of capability dismissals. They are by no means straightforward. It's a complex area, particularly given the overlap between unfair dismissal and disability discrimination law, and therefore it's an area where it's always sensible to take advice from HR or legal as appropriate. So I think that concludes what we had to talk about on the topic, and I don't know, Antonia, if we've got time for any final questions.
Yeah, we have. We've had a lot come through, so I don't know if we're going to be able to cover all of them, but I'll try and kind of pick some themes that are coming out across the questions. So one that we've had is around Bradford factor, and I think Grace, you'd mentioned this, that they're kind of the hitting a certain points, trigger points to then go through meetings and potentially warnings, and how you can use that for disability related conditions. And I think it's probably that favourite lawyer's answer, which is it depends, which is not desperately helpful, but just because somebody has a disability doesn't mean that you can't manage their absence. I think that's something that a lot of people feel, it's a disability, there's nothing I can do. And that's not true. You just have to do it in a way which is not discriminatory and where you've complied with your duty to make reasonable adjustments. And so something like Bradford factor triggers, in my experience, you need to assess whether adjusting the triggers, for example, will actually alleviate the disadvantage. And this is going back, Simon, to what you were talking about in terms of would it work in terms of a reasonable adjustment? And I've certainly seen cases where a tribunal has said, well, actually, even if you adjust the trigger, the absence levels are so high, they're still going to trigger the higher triggers because of the level of absence. And therefore, that's not reasonable because it's not going to alleviate that disadvantage. So I think it very much comes down to what the triggers are, what the condition is, what the level of absence is, as to how you can apply something like Bradford factor. I don't know if either of you have got any other experience of that.
Yeah, I think it's also, if you can have a think about why the triggers are set at the levels they are, because a lot of the time disability discrimination claims will come down to whether or not the unfavourable treatment can be justified. And so if you've got completely arbitrary triggers that are automatically triggered anytime an employee reaches that level, that's likely to be discriminatory. But if those triggers have been thought through and there are genuine business reasons behind why absence cannot be tolerated at a certain level, you're into the territory of being able to explain to a tribunal why you can't accommodate absence beyond that, even though you appreciate the employee has a disability.
I couldn't agree more. I think that's absolutely spot on, Grace. And I think so it's really important. I think it actually is in a lot of cases as important to still hold the meeting that the trigger gives rise to, even if you don't then impose any sanction as a consequence of it, but to still make everybody aware and log the fact that absence causes internal difficulties for colleagues and the business generally, I think is really important. And if you therefore choose to ignore those meetings altogether and don't put those, make those points, that can actually work against you by the fact that, well, you completely changed the process and it didn't cause you any difficulties, did it? So I think the important thing is, just because you have a meeting doesn't mean that automatically, as night follows day, that you have a warning comes as a consequence of it. You can have the discussion without the warning, which allows you, as Grace says, to put that benchmark down to say, this is causing us problems. We accept that those problems are there and we're going to work with you in relation to that, but that's not going to move away from the fact that it's causing us problems.
think that leads nicely on actually to another question, which is if we've agreed something like working from home as a long-term solution, should we have evidence of that? And actually, I think that's a really good point where it comes to reasonable adjustments. A is documenting both what you've thought about and discounted and the reasons why you've discounted it, as much as the things that you are putting in place, but also to keep that under review, because in my experience, medical conditions don't tend to be linear. There will be ups and downs, and therefore reasonable adjustments need to have some flex to them. Again, I don't know whether there's anything else you want to add to that.
I don't think it's just health that isn't linear. A business isn't linear
Yeah,
either.
yeah,
So the demands of the business may change, and therefore what was reasonable to allow somebody to work from home may actually change. You'd need to be able to demonstrate that the business rationale has changed, and actually working from home no longer fits with that, and it'll be less common than the health situation deteriorates. But yeah, I mean, what you say in terms of I like to describe it as a sort of decision log or a file note in relation to what's going on. Absolutely vital to note what you have considered, what you haven't considered. And whilst you'll think that you'll remember, so much happens in your life, both working and personal, between making that decision on the one day and 18 months later having to justify yourself in an employment tribunal, that you will not remember all of the ins and outs, and you can have behaved as admirably as possible, but if you can't remember it, effectively it never happened.
yeah. And I think just finally, because I'm conscious of time, but we've had a lot of questions around what happens when the employee refuses to either attend welfare meetings or go for an occupational health assessment or even comply with kind of the reporting obligations in terms of phoning in. So we've had a lot of questions around that kind of that general theme of non-cooperation. And I mean, I suppose there are two things maybe that initially jump out at me. One is if it's a willful refusal to follow a process, that's potentially a conduct issue. But obviously you need to understand what's causing that refusal. Is it just willful, or is it actually a manifestation of the medical issues that they're having? But potentially it's a conduct issue, which could be a disciplinary matter. The other is, and it kind of comes back to that point we were discussing earlier, which is you can only go on the evidence that's available to you. And as long as you, again, document the requests that you've made and the responses that you're getting, to a point, there will come a point where you have to make a decision because you can't sustain the ongoing level of absence. Again, I don't know whether either of you've got anything else you want to add to that.
Yeah, I think sometimes when you get the situation where the employee just isn't interested in engaging with the process, that can sometimes be indicative that the employment relationship has broken down as well. So sometimes you could even be into the territory of looking at a dismissal for some other substantial reason on the basis that they're just disinterested in coming back to work.
Yeah, and I think telling the story back to the individual when you're getting to that, if you're getting to the point where you think you have to dismiss, particularly, or you're making fundamental decisions based upon the information that you have, telling that story back to the individual in a letter to say, the information we have tells us this, 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 or this. And as a consequence, we are considering this, this, and this. And in the absence of any further information, that is likely to be the decision that we're going to make. Then an employee who is subsequently dismissed for not providing any further information that alters that situation really can't have too many arguments. So telling them the story about what you're expecting, it's not a game of cards where you're hiding what you've got until such time as it comes to the last one and you put them down and go, ta-da. It really is a question of you should be sharing what you have, because then they know what you're going to decide and it's not a surprise.
Thank you. I'm conscious we are on 1:15.
Yeah.
So
I'm
well,
really
thank
sorry for
you.
people. Yes, absolutely. I'm
Yeah.
sorry that we're not able to answer all of the questions that this topic gives rise to. But thank you very, very much, everybody, for attending. Is there a feedback?
The feedback as you log off, and then the slides and the recording will be sent to you. And then obviously you've got our details there on the screen. If anyone's got questions that they want to follow up with us directly, then please do. Thank you very much.